Good afternoon. All right, I'm going to call the 1:30 civil non-jury trial calendar for announcements. Position 1 is State Farm versus Rodriguez Smith. It looks like, what happened here? I don't know. Is anyone here for this case?
Silas Harrington here on behalf of State Farm, Your Honor.
Jamil Urban here on behalf of Rodriguez Smith and I have someone else here with me as well, my adjuster.
Okay. I'm sorry, Mr. Irving, you said you were present on behalf of the defense, and what
Yes.
else did you say?
Oh, sorry, I said that also my adjuster is here with me.
Okay. Um, was there anybody else on this case?
There was another, as far as an attorney?
Yes, I feel like.
Yes, Miss Guidry, she's battling the flu, so I stepped in.
Okay. All right. Maybe that's
Yeah.
my confusion. Okay. All right. Are you all ready to proceed, Mr. Harrington?
Your Honor, we are ready to proceed. I do have one witness, Mr. Jason Hill, who is here. How are we going to resolve the pair of pending motions? Are we going to resolve those today?
Indeed. Um, let's see. A motion to add a party and motion to
And
transfer a case. Is that what you're referring to?
yes, Your Honor.
Um, let me talk to my staff attorney and get back to you. I'm trying to figure out what was our plan of action for that. Whose motion to transfer?
It is the defendant's motion. They're kind of like, they're almost, it should have probably been just one motion, truthfully. I think it was just easy to do them in two. But the motion to transfer is based on, it will technically be based on your ruling on the motion to add the party.
Okay. Let me get back to you on that.
Okay.
Just,
Thank you, Your Honor.
All right. Position 2 was dismissed without prejudice. It's Citibank versus Janet Garcia. So hopefully no one has appeared. Position 3, Capital One versus Joshua Raphael. Was a consent judgment filed there. Position 4, Capital One versus Charlene Wilkins. I think I have a proposed consent order there. Was anyone present on that matter?
I'm here today on behalf of the defendant. Yes, there was a consent order, a proposed consent order that was e-filed for your honor's consideration. My client has already taken care of the settlement payment obligations, and it'll be a dismissal within probably a month.
Your Honor, who's the plaintiff's attorney on that case, please?
Christopher Tang.
Okay, that's not ours. Thank you.
You're welcome.
Okay. All right, give me one moment, Ms. Sant.
Of course.
I have been in court all day for the last 2 days, so I may have missed that.
That's perfectly fine. It was submitted, I believe, on Monday. And it does appear to be on the docket. So I do believe it has been at least received.
Yeah, I see it now. And so it's not a consent judgment.
Correct. It's just a consent order since the payment had already been submitted, and they're going to dismiss it. We didn't want to ask your honor for a continuance since this was indeed a trial calendar. So we decided we would do a consent order unless your honor wishes to continue it, and it could be a dismissal. It really doesn't matter to us.
Okay. No, I'll sign it. And so we'll get this e-file today.
Perfect. That concludes my business for today. May I be excused?
Yes, ma'am. Thank you.
Thank you very much. Have a wonderful day.
You too. All right, position 5, Capital One versus Calvin Watson. Is anyone present on behalf of Capital One? Yes,
Your
Calvin.
Honor, oh,
Yes.
I'm sorry. Good afternoon. If I may, who's the counsel of record on that for Capital One?
Anna Chima.
No, that would
Nah,
not be
Chima.
out.
Okay. Also I have, let me just check the docket, because sometimes when people don't show up and they don't call us, they have settled. And it was indeed dismissed with prejudice today. All right. Position 6, Bank of America versus Eureka Platt.
Good afternoon again, Your Honor. Uber for Bank of America.
Good afternoon, Your Honor. Carlo Caldwell for the defendant.
Okay. And Miss, is it
Uber,
Yubo?
Uber.
You're here as appearance counsel for Bank of America?
No, Your Honor.
You
I'm with the
are
firm of Lloyd and McDaniel.
okay. My mistake. Apologize. I didn't see your name on here, so I just assumed. Okay, and Mr. Caldwell's here for Eureka Platt. Are you ready to proceed? It looks like a motion for summary judgment was filed at the
Yes.
11th hour. Who filed this motion?
Our office filed that motion, Your Honor.
Mr. Caldwell, what is your position on this? Typically, the case has been pending trial for over a month now. What is your position?
Yes, I was just gonna respectfully request just a few minutes to speak to Attorney Hugo.
Okay. I can put you all in the breakout room if you like.
Appreciate that.
Yes, please.
Okay.
Thank you, Your Honor.
Great. All right. I still have, it looks like many other people left. I suppose you all are witnesses, maybe? Let's see. Mr. Harrison, Mr. Irvin's matter. Oh, that's the court, I'm sorry. And Jason Hill is the adjuster.
That is correct, Your Honor. Mr. Hill is my adjuster witness.
Okay. And Lynn.
Linda is with me, Your Honor. That's my,
Okay.
yeah.
All right. Let me take a look at you all's matter and I'll be right back with you.
Okay.
Okay. Mr. Harrington and Mr. Earth. On this matter, so I had to re-familiarize myself with what was going on here. Those two motions that were filed, well, the motion to add party defendant, we have not ruled on. It was up for ruling on, on our internal calendar to be ruled on the 8th of December. And likewise, the motion to transfer, which was amended to a motion to transfer for inconvenient form, was up for ruling on the 15th of December because the court must allow 30 days for the opposing party to respond to that motion. So it seems like Mr. Harrington has now filed responses on both motions, and so the court can rule on them a little bit earlier than the date that we anticipated, but obviously we're not ready to rule on it today and to have a trial today. So what I will do is I'm going to rule on the motions this month. If my ruling requires us to reschedule this for trial, then I'll do that. If not, then obviously the cases will either be transferred, if necessary. But I will say this, and just taking a cursory look at the motions, the motion to transfer, I mean, I just need to look at all the case law, but it appears to me if the person is in default, they've waived venue. So I guess that's why it was changed to inconvenient form. And I don't necessarily think that Clayton County is that inconvenient to Fulton. But I would love to have one less case. But anyway, I'm going to make rulings on the merits and not necessarily my preference to have one less case on my docket.
And
So,
could I ask you a question, Judge, in the interest of
yes,
efficiency? All right.
yes.
If, say, for hypothetically, we were to withdraw the motions in order to dispose of the case today, would that be something that we could do?
Yeah, because the only reason why I would continue this matter is because
Because of
these
that?
motions were filed and I need to
Okay.
rule on it.
Okay, can I? All right, can I get like 5 minutes?
Sure. All right, Miss Uba. I hope I said it right. And Mr. Cardwell.
Yes, Your Honor.
Okay.
We've reached a settlement, and we're just asking for about 30-day continuance to submit the consent judgment.
Okay. So what I do on those, is it Uba?
Ubo.
Ubo, I'm so sorry. What I usually do in situations like this is I will reset it to another trial calendar. If you all submit that before the trial calendar, you'll be excused. If you do not, then I'll expect to see you. That's just kind of how I keep up with this because I have a lot of people who tell me they're going to do a lot of things and it doesn't get done. And so it falls through the cracks. So not saying that you're going to do that, but that's just my process to make sure that everyone stays on the same page.
Understood, Your Honor.
Okay, so I will continue this. Let's see, my next civil Zoom calendar is going to be on January 13th at 10 a.m.
Okay.
So hopefully you all will get whatever the consent judgment to me by that time. If so, you'll be excused from having to appear at that calendar.
May we submit it via e-file, or do we email it to your law clerk or staff attorney?
Either way, if you want a quicker response, it'll probably be quicker to email it directly to my staff attorney. And I can give you her email address if you need it.
Yes, I do, Your Honor.
Okay. With the e-filings, we check those. We get a report of those each day, but we really only go through them once a week, and to rule on each one and to sign whatever needs to be signed. So it's much quicker to email her. Where is
Okay.
my chat? What's happening here? Okay, I can just tell you. Regina, REGINA .Stokes, STOKES at Clayton County .ga.gov. Because I don't know what happened to my, oh, there it is. It came back.
All right. Thank you, Your Honor. I do have it.
Okay.
And that concludes my business before the court. May I be excused?
Yes, you as well,
Thank
Mr.
you.
Cardwell, unless you have something else.
No, I don't. Thank you, Your Honor.
Thank you. Okie dokie.
One more question for you, Your Honor. I
Yes,
guess
sir.
this is for Silas. Oh, can you hear me?
Yes.
Okay. I, in the interest of efficiency and trying to get the matter resolved today, if we withdraw it, then I guess we don't want to withdraw it and then the plaintiff can still ask for fees for the motion. Because we're withdrawing it essentially just so we can have the trial and get it all resolved.
You're asking us to withdraw our demand for attorney's fees.
In regards to the, I mean, I'm assuming that you're gonna ask, I know we spoke, you said you're gonna ask for fees related to the motion. I mean, unless we can still technically make an
Okay, to clarify the situation,
Do you all want to
We-
have a breakout room to discuss this?
We certainly can.
Sure.
I don't know if I need to be made a part of this conversation.
Oh, okay.
If
Oh,
you
good.
if you could include Mr. Hill and mine as
Sure.
well.
Okay.
Sure.
Yeah, you can just include all four of us. That's fine.
Okay, all right. Let me get my computer working again. Let's see. It's-
Judge, just letting you know that Kelly brought me over your calendars, so I have them.
Okay, thanks. Yeah, Judge Spencer put me as a stop on her Uber duties this morning.
Okay,
I ran my calendars out there. She offered to come get them for me.
gotcha. That was sweet, but thank you.
And actually, I need to do the bench warrants for this week. I need you to scan them, at least for the arraignments, and send them back to me or upload them to the other drive.
Right, yeah, that's what I've been doing. Let me ask you though, do you still have the jail calendar from yesterday? Because I don't see that one.
I think I do.
Okay, okay,
I found it on my desk and I said, oops, I was supposed to send that. So I
okay.
can tell you what's on there if you need to know. Or I can just scan that page, because like I said, I can scan a page. It's easy to do that. I'll just scan that and send it to you now.
Okay, sounds good. Thank you. I'll just put it with the rest.
Okay.
Reset the cases accordingly.
I also have looked over the May through October
Yes.
calendars, and there were maybe one or two changes that I need to make. So I'm gonna bring those in and leave them for you on your desk on Friday when I come to perform that wedding.
Okay. All right. Sounds good.
All right, Judge. I think everybody, was he back?
Waiting on Mr. Harrington.
Um,
I saw that you said you asked for help. I just closed the breakout room,
Yeah,
assuming
okay.
he still has not left.
He's probably not looking at the screen.
Okay. Okay.
All right. So we have a question for you, which is that is there going to, at the last hearing, my understanding, I wasn't there, that my colleague who was there said that there was no discussion of fees at the last hearing, the motion to dismiss hearing. But Mr. Silas is under the impression that fees were discussed and there was going to be a hearing set for fees separate. I
So,
thought
Your
that,
Honor, let me tell you what I recall in the last hearing. We had a damages hearing on 9/4/25. At that hearing, defendant requested a witness attend the hearing who needed to appear via Zoom. It was an in-person hearing. You declined to allow her to basically set up a Zoom that morning, and you indicated you would reschedule it for a Zoom damages hearing, and we would do the damages hearing and then a hearing on attorney fees. There was never any indication of whether you would award attorney's fees or not, but you did indicate that you would have a hearing on attorney fees. And we're in this situation right now where the defendant wants me to waive attorney fees that we were going to ask for responding to these two motions, which are currently pending. If we will agree not to ask the court for attorney's fees specific to responding to those motions. And
These motions filed after that hearing.
That is correct, Your Honor. And in our responses, we indicated we would be asking for attorney's fees for having to respond to them. We told the other attorney.
I haven't read your response yet, so.
I'm sorry, Your Honor.
It's okay.
We indicated to the defendant after reviewing her motions, the pending motions, we asked her to withdraw them and told her if she didn't, we would ask for more attorney's fees. We already did this once. Her first motion, we said, please withdraw or we're going to seek attorney's fees. She didn't. We filed a response. We saw attorney's fees. And when we read these two motions, we said, please withdraw. We're going to ask for attorney's fees. She didn't. We responded, we're asking for attorney's fees for these two motions. I'm going to say what I heard the defendant say, but I can't speak for the defendant, but he's asking me to waive the attorney's fees we would ask for responding to these two pending motions. And I'm willing to do that. We still are going to ask for attorney's fees for having to respond to the initial motion and appear at that 9/4/25 hearing because we were thinking the case was going to be over that day.
Mm-hmm.
so my question is, I'm not even disregarding even the waiving. Are at the original hearing, or I guess the last hearing, I'm just trying to get a good understanding. Were attorney's fees discussed and was there some, I guess, order or announcement that there will be a separate hearing or after the damages hearing, whenever that may be, on fees for that motion? I don't believe that. My understanding is attorney's fees weren't even discussed at that hearing, but if Your Honor says that they were, then obviously they were, and then I'm not asking them to waive his fees for that one. I'm just want to know.
I typically speak through my orders, so let me go back because I don't recall that. But hang on one second. Let me just make sure. So. Order. So the last order that I entered in this case was back in July.
Yeah.
And that was the default.
Yeah, I think
I'm sorry.
No, go ahead, Judge. I'm sorry.
There was another hearing scheduled in October, but both plaintiff and defendant had to file conflict letters I had a trial in I had a trial in Savannah, and I believe the defendant had a jury counsel for defendant had a jury trial in like Fulton or something.
Mhm.
So this is the second rescheduling of that original 9/4/2025 hearing.
Mhm.
Yeah, and I believe
Um,
that hearing you orally denied the motion. I don't even think you entered an order at that time. Because I think there was a discussion about witnesses being able to.
yeah, I never heard this case.
Yeah, right.
So that's what we're here for today. So, obviously after I enter an order determining what the damages are, I don't know if there was a separate motion for attorney fees. I feel like I recall that because it was some motion that was filed that, I believe plaintiff thought was really frivolous, and I don't remember what that was right now, but I do recall there being some discussion about attorney fees because, there was a motion to dismiss.
The motion to dismiss was ruled on orally that day that they showed up in September.
Okay, all right, so
That's
I guess I did.
correct.
Yes, so there will be a separate motion on fees related to that motion after you hear the case.
Correct. That's correct. That's my understanding.
Okay,
Unless
and that's,
plaintiff withdraws their request for attorney fees, but that's my understanding. And
Okay.
obviously, I don't know whether or not they would, that attorney fees are warranted. I hadn't got that part yet.
okay, all right. So just to be clear, because I want to go forward today so we can at least get this part of it, because so if
Mhm.
that's going to happen regardless, if there's going to be a separate hearing set on the fees regarding that initial motion, then if our agreement still stands, Silas, we can just go forward with the trial today and we'll worry about the
That's
fees.
fine. No, I'm fine with going forward.
Yeah.
Okay. Do you all need this matter taken down by the court reporter?
I don't need takedown.
Mr. Irvin?
Yeah, we'll take it down.
All right. Ms. Scott, if you would send Mr. Irvin, or Mr. Irvin, if you would send Ms. Scott whatever information she needs, and I will prepare myself for a hearing.
Ms. Scott, if you could please send me that as well. If the defendant will split takedown costs.
Right.
Put it in the chat for both of you.
Thank you, Ms. Scott.
Mr. Hill, could you please turn on your camera and your mic, please? Thank you.
Okay.
Mr. Irvin, I need your information. I don't have it.
Okay, which information do you need from me?
Address, phone number, email.
Okay.
You can send it to the address I'm putting in the
Okay. Do you have Ms. Guidry's, or would you have needed that too? Because I want to say it's the same if you already have something for it.
say that again.
Okay.
She's not the regular court reporter, so she probably
okay.
was
Gotcha.
taking it down.
Let me get that for you.
Okay. And then I will invoice both of you since you're splitting it.
Yes. Oh,
I believe we'll be comfortably under an hour. I hope.
would you like me to put it in the chat, Ms. Scott, or just like email you this?
You can just email it to me.
Okay, perfect.
Thank you.
All right, Ms. Scott, I have your information. Thank you.
I'll be right.
You're welcome. Thank you.
All right. So let me look up one more thing. Actually, what about my thing? All right, Ms. Scott, are you ready?
Yes, I'm ready. Thank you.
All right, this is the matter of State Farm Fire and Casualty Company as subrogee of Marlene Adlam versus Rodriguez Kentrail Smith, case number 2024 CV 03371. This matter is on today for a hearing on damages. The plaintiff filed this complaint on or about June 19th, 2024. Service was made on the defendant. There was no answer filed. The plaintiff moved for a motion for default as to liability, which was granted by this court and scheduled for a hearing on or about September 4th, 2025. At the time of that hearing, I believe it was continued because the defense wanted to present witnesses remotely, and at that time we were in person in the courtroom. The court continued the matter to October 8th, 2025. Both sides had conflicts on that day, could not attend that hearing. The matter was continued to today. Since that time, the defense has filed two motions, a motion to add a party defendant and a motion to transfer the case for inconvenient form. Those motions are pending. I have been informed by the attorney, Jamel Irvin, who was appearing on behalf of the defense today, that those motions are being withdrawn. Is that correct, Mr. Irvin?
That is correct, Your Honor.
All right. Is there anything that I have missed in the providing the procedural history of the case, Mr. Harrington?
Your Honor, no.
All right. So at this time, well, I don't know if I said for the plaintiff, Mr. Silas Harrington is present, and for the defendant, Mr. Jamel Irvin is present. Mr. Harrington, are you ready to proceed? You may do so.
Yes, Your Honor. Just very briefly, this is an automobile subrogation case. Plaintiff is seeking a total of $10,336.05. I have one witness today, Mr. Jason Hill. If the court would prefer, I can swear him in and then place him on the stand.
That's fine. And just for the record, we are all appearing via Zoom for a virtual hearing. You may proceed.
Mr. Hill, okay, never mind. Mr. Hill, could you please hold up your right hand? Do you solemnly swear or affirm the testimony you provide for this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, Mr. Hill. Could you please state with whom you're employed?
State Farm Insurance,
In what capacity?
auto estimatic appraiser,
And how long have you been in that business?
over 28 years.
Okay. And by virtue of your training and experience, are you familiar with the fair market value of vehicles before and after collisions?
Yes.
Are you also familiar with the reasonable cost of repairing damaged vehicles and reasonable rental?
Yes.
And you were familiar with this file?
Yes, I am.
Could you please detail to the court how you're familiar with this file?
I was requested to testify on behalf of the case, but I have reviewed all of the details as far as everything in the claim.
Okay. And what was the vehicle involved in this claim?
2012 Honda Civic,
And what was the fair market value of that vehicle?
$11,433.46.
And this vehicle was struck on 7/19/2022, correct?
Yeah, that's correct.
Okay. And this vehicle was struck by the defendant?
Yes,
Okay. And was the vehicle a total loss?
yes, it was.
Okay. So State Farm totaled this vehicle.
Correct.
Okay. Was this vehicle sent to salvage?
Yes, it was.
Okay. What was the net salvage value immediately after the casualty before repairs were made?
$3,112.
Okay. So what was the difference between the fair market value and the net salvage value for this vehicle?
Difference would be $8,321.46.
And State Farm did this to try to recoup losses?
Pardon?
And State Farm did this to try and recoup losses?
Yes, correct.
And this is standard operating procedure?
Yes.
Okay. What was the amount of reasonable rental tow and storage fees associated with this accident?
I've got $2,014.59.
Okay. And what was the total amount of damages State Farm incurred for this?
So it'd be $10,336.05.
And Your Honor, that concludes plaintiff's initial questioning of the witness.
What was the $2,000 amount for again?
Your Honor, that's tow, rental, and storage costs.
Okay. You just said it really fast. I was just trying to
Yes,
make
Your
sure.
Honor, tow, rental, and storage costs.
Okay. All right. Any cross-examination, Mr. Irving?
Yes, Mr. Hill, you stated that you're an appraiser, is that correct?
Yes, that's correct.
And did you appraise this vehicle?
Not personally.
Okay, so you never actually saw this vehicle, that's correct?
That's correct.
And so how did you determine the fair market value of the vehicle? If you've never seen it?
We have a vendor that actually determines the values of the vehicles. In this particular instance, this estimate was prepared by one of our direct repair facilities. And I did, of course, go through and confirm that everything that they had prepared was consistent with what the vehicle needed for repairs.
Okay, and do you know how much the repairs were?
Total repairs. I can get that for you in just 1 second because I don't have it off the top of my head.
No, I want you to tell me if you know off the top of your head. I don't necessarily want you to look it up.
Yeah, I got you. Get the right one here. Bear with me 1 second. Total estimated repairs would be, as far as what the shop wrote up, got a slight delay. Looks like $6,592.79.
So it would have costed $6,592.79 to repair the vehicle, is that correct?
That's an initial estimate, so that is not after tear down or
Okay,
anything of that nature. So it easily could have increased.
okay, but you don't have the increased number, do you?
No, the vehicle was determined to be a total loss at that particular number.
Okay, and do you have any information on why it was determined to be a total loss?
No, I do not.
Okay, and do you know when this vehicle was taken into this shop?
I have approximation on that information. Looks like the vehicle did not get released from the other insurance company until approximately November of 2022.
Okay. So you said the first time that this vehicle was viewed by, I guess, by State Farm, was in November of 2022.
Correct.
And can you recall for me when this accident happened?
That'd be July 19th of 2022.
Okay. Do you know if there is any, do you know if there are any, if there was any additional damage to the vehicle after July 19th, 22, or before November of 2022?
That I can neither confirm nor deny that.
Okay. And in regards to fair market value, you stated the fair market value as, you guys determined the fair market value to be $11,433.43. Is that correct?
And there, yeah, 46 cents, correct.
Okay, 46 cents, sorry. Okay. And is that fair market value, that's not an objective number, is it? Like there could be other estimates of the fair market value, is that correct?
Yeah, it's to some degree, but what the vendor does is they pull comparable vehicles with similar options, similar mileage, and within a certain market radius, excuse me, and that's how they come up with that determination as far as value.
Okay, do you have any of those comparative markers or comparative values from the vendor?
They may possibly be in the file, but I did not review that particular aspect of it. I mean, this is a vendor that we utilize for all of our claims.
Okay, so you don't currently right now, you don't have any documentation showing that the fair market value is accurately $11,433.46. And
Well, that would,
I'm asking, do you have it currently? Like,
it would be in the claim.
and when the car, I believe you said the salvage value of the car was $3,112. That's correct?
Yeah, that was what was recuperated.
Okay, so State Farm got $3,112 for this
Yes,
vehicle.
correct.
And can you recall for me the amount paid in the rental fees? Did you state that?
We're showing $2,014.15 for rental tow and storage.
Okay, but how much particular was for the rental fees? Do you know?
I do not have that breakdown.
Okay. You don't know when the car was rented either, do you?
Well, originally it appears that it appears, I don't know, that they were originally with the other insurance company and then State Farm, let's see, we started providing a rental to our insured. It appears to also be in November of 22, whenever I believe at that point, whenever the owner decided to pursue State Farm.
Okay, so the rental fee, you guys paid rental fee starting in November of 2022, that's correct?
Well, that was when it was initiated.
Okay,
But we ended up covering the rental total.
okay. And are you aware of any rental payments made by the other insured?
The other insured, clarify,
I mean, I'm
please.
sorry, the other insurance company, so who you said?
No, I do not have that information.
Okay. So you don't know if there are any other payments made to I guess, your insured in regards to rental
I
payments?
do not know that information.
Those are all the questions I have.
Mr. Harrington, any redirect?
No, Your Honor.
I have some questions. Why, Mr. Hill, why was the vehicle determined to be a total loss at basically $6,600 if it was worth over 10 grand or 11 grand, I'm sorry?
A lot of times what happens on those is we factor in the value of the vehicle, what the potential salvage return is. We will also look at potential rental expenses, and it ends up being a financial decision as far as whether it's repairable versus a total loss.
Okay. You also mentioned that you all didn't get the vehicle in your I can't remember what you called it. It's the repair shop, I guess that partners with you,
Yeah, correct. It's a direct repair.
direct repair,
Mhm.
until November, until it was released by the other insurance company.
Correct.
What does that mean?
Essentially, our insured started the claim with the other insurance company. And obviously, I don't have information as far as how everything went on that side of it. But that went on up until November. They deemed the vehicle a total loss. The other insurance company also deemed it a total loss. And then they took it to the salvage yard. And then at that point, uh, the things played out that where our insured then had to come to State Farm, and it took several. It looks like it took several weeks before the other insurance company even released it, so we could get that vehicle out of the salvage yard.
When it's taken to the salvage yard, if this had been, and I'm asking this based on your experience that you've just testified to that you have,
Mhm.
when an insurance company takes a vehicle to the salvage yard after declaring it a total loss, do they typically pay the owner something for that vehicle, or is that that's just something that they do?
It can be handled either way. Um, it can be handled either way to answer your question, Your Honor.
Does anything that happened here seem unusual to you in this case? With it being declared a total loss by one insurance company, the defendant's insurance company, and then the car comes back and then declared a total loss by State Farm's insurance company.
Well, I mean, we would
But
like
not State Farm's insurance company, I'm sorry, by State Farm.
Yes, I understood. Thank you.
Okay.
Yes, it is a little different. I mean, it's one thing. This happens quite often where customer gets in a wreck, they had other insurance companies handling it, you run into a limits issue, and then they're already kind of down that path, which is where we were here, where it went to the salvage vendor. And then State Farm wanted to put our eyes on it because we did a virtual while it was at the salvage yard. So to clarify this, so that way it's full understanding of what kind of how we got here
Mhm.
is we did where the salvage vendor took photographs, and then we had a virtual individual that prepared an estimate based off of those photographs. The photographs did not clearly depict all the damages, so when we've initially prepared a State Farm written estimate, it looked like it was a repairable vehicle. That's why we towed it out to a direct repair facility. And once they got a hold of the vehicle, opened the trunk, removed the inner pieces, and was able to see the extent of the damages, that's what
Mhm.
really escalated the expenses as far as the repairs.
Okay. All right. I think that's all the questions I have for you. Thank you.
Yes, ma'am.
Mr. Harrington, did you have any questions based upon the court's questions?
Yes, Your Honor. Mr. Hill, does State Farm often get into a situation in which the insured will request that State Farm make repairs rather than total the vehicle, or ask that the vehicle be repaired when it is close to the value of the vehicle?
Yes, we do get those requests.
And does State Farm sometimes attempt to mollify the insured?
To
Did you
honor
say
their request.
Will State Farm attempt to repair the vehicle in these situations where they might otherwise total it?
Those situations do occur, but all factors have to be considered before that decision would be made.
And in this case, State Farm determined it was a total loss after looking at the repair estimate, correct?
Correct.
And in your experience, do repair estimates usually go up or down?
I have seldom seen them go down, so I would definitely say up.
I have nothing further, Your Honor.
okay? Mr. Irving, do you have any questions based upon the court's questions?
Yes, in reference to the cost of repair and the total loss, is it, in this case, do you know if the total loss was determined simply because of the value of repairing it versus just totaling out the car, or could the car not be repaired at all?
Any vehicle is repairable, but it's a matter of finances. But in this case, I did notate this morning when I was reading through the file, because I read all documentation that was in there. The owner of that repair facility, we spoke with him, and he also indicated that this vehicle needed to be a total loss. And when I reviewed his estimate, it was a good estimate, but I could tell that there was going to be more things that were going to be required.
And do you have the number of that estimate? Like the
No,
total cost it would cost to repair it? I know we said about $6,600.
correct.
So it was more than that to repair it?
It most likely would have been more. And the other factor that I did see on his estimate this morning when I reviewed it is he had notated that the vehicle needed a rear floor pan, and the rear floor pan was not available from Honda at the time that he wrote it. It was on national back order with no release date. So that would have also factored into a total loss decision.
Those are the questions I have.
I think I had one more question. I'm so sorry, Mr. Hill. The amount that you said was the difference between the value of the car, the 11,433 versus the salvage, which you all received when you sold it to salvage for 3,112. How much of that went to the owner of the vehicle?
We would have paid the owner out for the fair market value of the vehicle.
So they got the $11,000 amount.
Correct.
Okay.
Minus any deductible also. So there might have been a deductible that would have been taken out of that.
All right. Anything else, Mr. Harrington?
No, Your Honor.
Anything else from Mr. Hill, Mr. Irvin?
1 second, let's check. Yes, in regards to what you paid out to the owner of the car, Ms. Adlam, would State Farm have paid a different amount had there been any payments from, I guess, Fred Lawyer Insurance, the at-fault driver's insurance to Mrs. Adlam?
I'm not familiar with if there were any payments on that. So, I mean, historically, we make payments to our insured or claimants in the situation, depending on who it may be. And I honestly, I don't know the answer to your question. I'm not in a claims handling role, so I do not know how that would have been handled.
Okay.
All right. Thank you. Mr. Harrington, do you have another witness to call?
No, Your Honor, that is my sole witness.
All right. Does the defense have any evidence to present?
Yes, I'll call Miss Linda Davila to stand.
Who's that?
Linda Davila.
Okay. All right. You want to swear in?
Can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth and solely the truth?
Yes, sir.
Can you introduce yourself, please?
My name is Linda Davila,
Ms. Davila, where do you work?
Fred Lawyer Insurance,
How long have you been there?
20 years,
Okay, and what is your title at Fred Lawyer Insurance?
a litigation manager.
Okay, and as a litigation manager, what is your role in regards to claim files?
Once it comes into the litigation department, then I oversee those claims.
Okay, and was this matter that we're here for today a claim of yours in your department?
Initially, it was not until the suit was filed by State Farm, then it came into my department.
Okay, and so you're familiar with this file, with this claim?
Yes, sir.
Okay. Did you review anything in prep for today?
Yes, sir, I did.
Okay, what did you review?
Basically the file just to see, the history.
Okay. And do you got, at Fred Lawyer Insurance, do you use a system to keep track of claim files once they enter into litigation?
Yes, we do.
Okay. And what's the name of that system?
It's Guidewire.
Okay. And what will that system tell you when you go into and look into a file? What will you see?
It gives us all the information in regards to the claim handling, notes, any payments, basically every information that we need for the claim.
Okay. And I know that you said you're the litigation manager. So when a claim, specifically this claim, when it came into litigation, did you review any payments made out to the claimant, Miss Adlam, this matter?
Yes,
Okay. And when you're reviewing payments that that have been made or will potentially be made, do you review anything to determine how much the payment was or should be?
yeah, we can look it up. What we do is it'll tell us like how much was paid out, and then
Mhm.
we can click on there and it'll bring up another screen so we can actually see, the check, or it's not the actual check, but how it was made out, like who it was made out to, the amount, the date.
Okay. And when you looked at this file, did you review any estimates?
Yes.
Okay. Can I share my screen for a second?
Are you attempting to put something in the evidence or
Yeah.
what would, okay. Yeah, let me see. Okay, yeah, you have permission to do that. Oops. I'm not trying to do.
All right, Ms. Davila, can you see my screen?
Yes, I can.
Okay, I'm showing you what's been marked as Defense Exhibit A. Um, what is this?
That is the initial estimate.
Okay, and is this the estimate for Miss Adams' car?
Marlene Adlam, yes, it shows the owner.
Okay, and have you seen this before?
I've looked over it, yes, sir.
Okay, and is this a true and accurate depiction of the estimate that you previously viewed?
Yes, sir.
Okay, at this time, I move to admit Defense Exhibit A into evidence.
Any objection?
Well, it's 15 pages. I would like to.
Well, the other ones are different exhibits, but I'll show you the full Exhibit A, sorry.
Can you make that bigger?
Yeah, let me see how much, tell me how much. Is that too big now?
No, it's just not centered.
Okay, hold on one second.
Okay, that's I think that's perfect.
Is that
So
better?
yes.
I can't see what you guys see.
No further objections on Exhibit A.
Okay. Defense exhibit A will be admitted without objection.
Can you tell me what the price, the net cost of repairs was based on this exhibit, Ms. Linda?
$2,488.76.
Okay. And well, I'll continue to share for a second. Okay, and do you know if this $2,488.76 was ever paid to Ms. Allen?
Yes, it was.
Okay, and how do you know that?
We have it on the payment screen and we have a check.
Okay, I'm gonna scroll. I'm gonna show you what's been marked as Exhibit B. Since the screen. Can everybody still see my screen?
Yes.
Okay. All right. I'll show the full exhibit this time. Okay, Ms. Linda, have you had a chance to view that exhibit?
That one, well, that's a check if you want to, I don't know if you can see.
Yeah, I'm scrolling all the way up to I just went to the bottom. I'm scrolling.
Okay.
I'm sorry, yes. Do you know what this is?
Can y'all see? I mean, I can only see like part of it,
You can only see, I can't see what you guys can see. One sec.
but that's our, to show that the payment details
Okay.
for the check issuance.
Okay, and is this have you seen this before?
Yes, I have.
And it's a true and accurate depiction of what your system shows in regards to a payment?
Yes, sir.
Okay. At this time, I'd like to admit Exhibit B into evidence.
Any objection?
No objection, Your Honor.
Defense Exhibit B will be admitted without objection.
Okay.
Mr. Urban, I also want to remind you that you need to get copies of these exhibits to Madam Court Reporter at the conclusion of this hearing.
Will do, Your Honor.
All right.
Can you see my screen, Ms. Linda?
Yes, sir.
Okay, and what is this that you're looking at?
It's the front of a check,
Okay, and how much is the check?
$2,488.76.
Okay, and who is it addressed out to?
Marlene Adlam?
And is that $2,488.76 the same amount that was in the estimate from Exhibit A?
Yes, sir.
Okay, and what are you looking at now on this screen?
That's going to be the back of the check where she signed it, endorsed
Okay.
it.
So that is Ms. Adams' endorsement?
I don't know. I mean, there's a signature there and I'm assuming it's
Okay.
hers. Yes.
And do you have, outside of this check, I'm sorry, one second, outside of this check, in your system, does it tell you when a check has been cashed or deposited by a recipient?
Yes, when it shows cleared.
Okay, and does this check, does it say cleared in regards to this check number and this amount for Ms. Adams in your system?
Yes, sir.
Okay. All right. And do you know if there were any other payments made to Ms. Adlam?
There was one other payment.
Okay, second. Sorry. And is that payment $232.64?
Yes, sir.
Okay, and does it say that what that payment was for?
Rental cash out. So the
Okay.
rental.
And was this check I guess deposited or cashed by Ms. Adlam as well?
Yes, sir.
Okay. And do you know when this check was cashed or deposited by Ms. Adlam?
9/28/2022.
Okay. All right. And I'm gonna stop sharing my screen. And in your review of the file, in your review of the file and looking at the totality of the payments made, were there any other payments made to Ms. Adlam?
No other payments on our end.
Okay, and was there a valuation of the car determined by Fred Lawyer?
There was two estimates.
Okay.
So the initial and then the supplemental.
Okay, and after that, what was there in your review of the file, was there a determination on how much the car was worth?
Yes, through Carfax.
Okay, and do you recall how much that car was worth?
I don't, I think it would, I want to say about 8,870 from what I recall.
Okay. All right, and did Fred Lawyer Insurance make did Fred Lawyer Insurance pay the 8,870 to Ms. Adlam?
No, sir.
Okay, and why was that?
Well, the initial estimate was in August of 22. She took the vehicle into a Honda dealership. I don't remember the name of it, but which was about 2 months later. And at that point, they called in a supplemental estimate. They were asking for someone from Fred Loya, an estimator, to go out and look at the vehicle. and determine if there was any other damages, which they did. And then at that time, they determined the car to be a total loss.
Okay. And you said that, and just to clarify, that total loss was that 8,870 number that you stated?
Yes, sir.
Okay. I think that's all the questions I have for now.
Any cross-examination?
Ms. Davila, do you know when Loya determined this vehicle to be a total loss?
It was sometime after October of 20, I don't know the exact date.
Okay. Are you aware of any release signed by State Farm's insured?
No, I'm not.
Okay. And are you aware of any repair shops that this vehicle was sent to?
I know there was a Honda dealership. I don't remember the name. That's who called out the supplemental. So it was in October. The date of loss, I think, was in July. The first initial estimate was in August. And then the second one, when it went into the repair facility, was in October.
And what was that supplemental estimate, the last supplemental estimate for repairs?
I don't have that information.
But whatever the supplement estimate was, it was sufficient to total the vehicle?
Yes, sir.
Okay. Did Loya then send the vehicle to a salvage yard?
Yes,
Do you remember what salvage yard?
Copart.
Okay. And are you aware of the payments made by State Farm to our insured?
Once the suit came in and that, that it was there. That's the only way I knew that there was payments. Other than that, no, I would not have known.
I have no further questions at this time.
Thank you.
All right. Any redirect, Mr. Irving?
Yes, so Slenda, just to be clear, there was a total of $2,721 and like 40 cents paid to Miss Adlam from Fred Lawyer Insurance for this vehicle.
Yes.
No further questions.
I'm a little, I have a question, Ms. Davila, and you may know the answer to this or not. I know that you are the a litigation manager, but after the first estimate in August of 2022, and your employer made the decision to pay Miss Adlam for the cost of the repair at that time. I guess I'm trying to figure out, why were you all still involved in this matter? Like, to me, if she made a claim with your insurance, she got an estimate, there was a she agreed to accept the amount of money for the for the repair. Why did they call you all out to do a supplemental estimate in October? Like, what was the purpose of that?
When the vehicle, so what happens is they take it there to get the vehicle repaired. I don't know why it took her 2 months to do that, but once they take it there on the estimate, it does state that if there's any other damages that are related to this accident, they need to call that number and we will send out an estimator to go out and reassess it.
Okay. All right, that makes sense. I understand now.
Yes,
Okay.
ma'am.
But you didn't get to the point of paying her out the full amount of what you thought the vehicle was worth?
No, ma'am, she went through State Farm.
Okay,
When-
so basically when lawyer said, hey, we're totaling this out, she said, give my car back, I'm going to State Farm.
Yes,
To,
ma'am.
yeah, okay, all right. Does the plaintiff have any questions based upon the court's questions?
No, Your Honor. Maybe it's more appropriate for after the questioning of this witness, but I would at some point like to speak to the issue, the legal issue of what the defendant spent, and if that is, if that's any kind of offset.
Okay. Mr. Irvin, do you have any questions based upon the court's questions? You're on mute.
Yes, Ms. Linda, normally when Fred Lawyer Insurance pays out a claimant in regards to their property damage, and a check is cash, do you see that, is it, in your experience, do you normally see that in your experience, do you see that the other insurance would still pay on that vehicle?
No, they should
And is
not.
it, okay, and in your understanding, normally once you guys pay it out, you paid her out for the car to be repaired or for the, I guess, the value of the car, correct?
Yes, sir.
Okay, and so the payment was for Fred Lawyer Insurance to essentially, accept responsibility for repairing it, for the payment of the repairs of the value of the car, correct?
Yes, sir.
Okay. No further questions.
Okay. All right. Do you have any other witnesses, Mr. Irvin?
I do not have any other witnesses.
All right. I'll hear from you, Mr. Harrington, unless you have any evidence to offer in rebuttal.
I have no rebuttal evidence, Your Honor, other than as clearly as I can restate, this is an instance where the insured attempted to file a claim through Loya, for whatever reason, was not satisfied, went back to her own insurance, State Farm, and then State Farm handled the claim. There's been evidence that she was paid. I saw a check for $2,488.76. There was some evidence for an additional payment, but I didn't see any check for that amount. So at some point, Loya, in an attempt to resolve this claim, paid the insured for repairs to her vehicle a check of $2,488.76. Clearly, Loya at some point decided this vehicle was going to take more than that and total the vehicle. They have their MSRP around $8,870. State Farm's MSRP is clearly different. State Farm incurred expenses in this case of $10,336.05. I understand that Loya did make a payment to the insured, but we're not here about what the insured may have accepted or not. We're here about the issue of State Farm's damages in this case. And State Farm's damages in this case are $10,336.05, regardless of what Loya might have done as they were attempting to resolve this claim. We didn't know they had paid this amount. It really wouldn't have changed anything. We wrote a check to the insured for the value of the vehicle, which we determined to be $10,000. I think the value of the vehicle we had was $11,433.46. This is offset by the salvage sale, and there was some additional rental. But at the end of the day, State Farm incurred the damages to which Mr. Hill testified to. And while I understand that the defendant has presented evidence that Loya did pay this sum to the insured, that doesn't entitle them to an offset. That doesn't change the amount of damages that State Farm incurred or the amount of damage that State Farm paid to their insured.
Well, aren't you seeking this money on behalf of Ms. Adlam?
Your Honor, we are seeking to recoup the damages we have already paid to Ms. Adlam. Ms. Adlam has already received every dime she is going to receive in this case, except for If State Farm recovers in this case, we do refund the insurer's deductible, which is, in this case is $250. So, except for the $250, the insured has been completely paid. And again, if State Farm recovers in subrogation, we do refund the insurer's deductible, like I said, which is $250. But the insured has been paid already. We are attempting to recoup the money that State Farm paid to the insured. We are standing in the shoes of the insured, but we don't represent the insured, and we're only attempting to recover money we have paid out to the insured.
So you're saying you're not in the shoes of the insured. That's not what this is what you're saying.
No, Your Honor. We're saying we do stand in these shoes of the insured, but State Farm has already paid the insured the money we are seeking. Every dime we are seeking in this case, we have paid to the insured already.
I get it. I'm listening.
The defendant caused the State Farm to have to incur this expense. I believe in this case there was a coverage issue. That was my understanding of it based on conversations with prior counsel. And for whatever reason, this one just kind of went sideways and we ended up here. Typically, these cases don't make it this far. Usually, I'm only here trying to recoup for State Farm in cases where there's no insurance or there's a dispute about liability. There's not a dispute about liability in this case because there's a default. So really the only issue is damages, and State Farm incurred this amount of damages. That's what we're seeking from the defendant.
Okay, Mr. Irvin.
Yes, on behalf of the defendant, yes, we acknowledge that we're here solely on damages, and at this point, while we are in default, 9/11/55 does require the plaintiff to prove their damages, and outside of the testimony of Mr. Hill, there has been no proof of any payments made to Ms. Adlam. There's been no proof of the amount of no proof of any payments made, how they arrived at that amount, and the validity of the amount paid. What we have seen and what's been entered into evidence is that there was $2,721 paid to Ms. Adlam for her car. And so my understanding is that the plaintiff is seeking $10,336.05. And if that number is based on the fair market value of the car and whatever was paid, it is our position that that number should at least be offset by what has already been paid to Ms. Adlam. Fred Lawyer Insurance or Rodriguez Smith shouldn't be on the hook for money that's already been paid out to her, because in that case, then it would be that the defendant is now being penalized twice, and the recipient of the funds, the driver, Ms. Adlam, is essentially recovering from two different insurance companies on the same claim. Essentially, she's double dipping, right? So we shouldn't have to then pay additional money because State Farm didn't do whether their due diligence or whatever they're alleging to pay, because we don't know what they paid. It was just Mr. Hill's testimony. There's no proof of any receipts, any checks, no bills, anything that has been entered into evidence. And so we also heard that they also recouped $3,112 after selling Miss Adams' vehicle. And so that is a $2,721.40, and which was paid to Ms. Adlam from Fred Lawyer Insurance originally, and then $3,112, and I think just $3,112, which 10,336 minus 10,336.05 minus that is $3,036.60, which we believe is owed to the plaintiff. At most, we believe it's owed to the plaintiff. And also, we heard that there was a dispute about the value of the vehicle in the first place. Right, so they had their fair market value was $11,000. The fair market value on behalf of Fred Lawyer Insurance was $8,000. So there's a value dispute that exists about the total market value of the vehicle anyway. However, based on the payments that have been made by Fred Lawyer Insurance and the money that was recouped on behalf of State Farm that went directly to State Farm in the amount of $3,112.00, we believe that the court should award no more than $3,036.60 to State Farm for this matter.
Okay. Mr. Harrington, closing on your motion.
I went to law school, so I didn't have to do math. However, I would point out that the defendant, as is his right to do, is being kind of generous with his numbers. The State Farm did recoup, he is correct, $3,112 from the sale of this vehicle at the salvage yard. However, that was already deducted from the amount State Farm was seeking. Had we gotten less than that amount, our claim would have been more. Had we gotten more than that amount, our claim would be less. The defendant is already getting the benefit of the salvage sale. A hypothetical, if a car was worth $10,000 and went to the salvage yard and sold for 12, extremely rare, but it can happen. State Farm wouldn't be entitled to recoup any damages for the fair market value of that vehicle. The defendant has already gotten the benefit of the salvage sale. We are only seeking the fair market value portion of this vehicle. We're seeking is $8,321.46. That is the difference between the fair market value and the net salvage value. It's $8,321.46. The addition we were seeking.
Go on. Sorry.
The additional we are seeking is additional expenses incurred during the processing of this claim, which primarily is rental that State Farm was required to pay and a small tow and salvage fee, which altogether accounted for $2,014.59. We can differ about their fair market value versus ours, but we cut a check for our fair market value, which is the larger number. We actually paid the insured the larger number. And we don't, I would say that again, the defendant has already gotten the benefit of that salvage sale. We always send these vehicles to salvage because we don't want to seek the money from the defendant when we could just get it back in the salvage sale. We always try and sell these vehicles for salvage, and hopefully we can get as much as we can. The more salvage, the better. But they've already gotten the benefit of that salvage sale. We don't need to just start knocking that off of any damage award.
So, Mr. Harrington, explain to me, logic-wise, why you all will agree that they've already received the benefit. They should receive the benefit of the salvage sale, but they should not receive the benefit of the money that they paid to your insured to repair this car to begin with.
Your Honor, first part of your question first. My interpretation of Mr. Irvin's argument was that the court should deduct the $3,100 from any award they granted the plaintiff. Now, I could have heard him wrong. It happens to me I've done it before where I mishear people.
No, I think that's what he argued. I don't agree with that. But my question is, if I agree that you should definitely get the benefit of the salvage sale, why should I not agree that they get the benefit of what they paid out to your insured? Then you ask your insured, have you received any other money from any insurance company? Don't they send out that little questionnaire to folks? I don't know, at some point I've gotten a questionnaire, maybe it was health insurance or something. But has anybody else been compensated or you made a claim with anyone else for this?
Your Honor, I'm not going to pretend like I know the answer to that question. I do not know what State Farm asked the insured, and I don't know what the insured's response was. My argument that they shouldn't be given the benefit of that payment is it did not change the amount State Farm paid to their insured. That is my only argument.
Well, that's just, what if State Farm had paid her $50,000? Because they just felt that she should have it. That doesn't mean that the defense insurance company has to bear the burden of what you decide to pay your insured. So I guess I'm going to prepare my order. I'm going to do some research on this matter, but I fully expect to be given an offset to lawyer for what they paid to Miss Adeline. And additionally, I think that if there is not an offset given here, that State Farm is subjecting their own insured to a lawsuit, which is probably not what you want to do. Unless
certainly not something that State Farm wants to happen, no, Your Honor.
Right. So I just, because they obviously have, she didn't use the money to repair the vehicle. Obviously. If they pay out, if I just order for them to pay out what you all spent, then now they are out of money. And so then they can go after her and say, hey, you owe us this money for repairing the vehicle because you never got it repaired. It was total. So anyway, I fully expect to give an offset to lawyer for this. However, I'm going to do my research. I'm going to prepare an order for you all. And because sometimes I start out thinking one thing, and when the law kind of guides me, I end up somewhere else. But I fully expect, hopefully I'll get you all in order by the end of the month here. I got some free time coming up soon. So please look for that. And thank you. Is there anything else?
I have nothing further, Your Honor.
I'm just assuming I can't say anything else, right?
No, not about this. He had closing on the motion. In the event, I don't know what things stand about attorney fees. Obviously, after the conclusion of this hearing, if the plaintiff wishes to do that, then I'll take up that argument and we'll go from there. Okay?
Thank you, Your Honor.
All right. Y'all have a good day.
Right too.
Forget to send me the exhibits.
And may we be excused, Your Honor, my witness and I.
Yes, everyone's excused. Mr. Urban, please send her those exhibits.
Thank you.
Thank you. All right. Thank you, Miss Scott. Oh, she gone. I'll see y'all later.